Good morning, everyone. Welcome to today's subcommittee hearing. Today we're going to look at several issues surrounding the administrative law judges, their independence, and the importance of due process as provided by the Administrative Procedures Act. The APA validates due process principles through the guarantee of an administrative hearing before an independent decision maker. These independent and impartial decision makers are most often administrative law judges, or what were called ALJs. The Office of the ALJ is unique in our federal government, although they are like federal judges in the sense that we expect them to preside over formal administrative adjudications independently. ALJs are, in fact, executive branch employees selected by the Office of Personnel Management to oversee adjudications as required by law. Though ALJs are spread throughout the executive branch, our focus today will center on ALJs from Social Security Administration as they employ the largest number of federal ALJs. ALJs are hired through the Office of Personnel Management. OPM is tasked with reviewing all ALJ qualifications, and OPM has made tremendous strides in providing qualified ALJs to Social Security Administration and elsewhere across the executive branch. At the same time, over the last 4 years, Congress has appropriated significant resources so that Social Security Administration could hire more ALJs to address its backlog of disability claims. Yet the agency has been unable to hire sufficient numbers of approved ALJs to tackle the rising backlog of cases, a backlog which topped 1 million last year. May I say, in my own state of Oklahoma, around 13,000 of those. But instead of hiring more ALJs in a misguided effort to expedite adjudication process, Social Security Administration is in the process of moving tens of thousands of pending cases from ALJs to non-APA attorney examiners who are regular employees of the agency and lack the requisite decisional independence. In March, Social Security Administration posted close to 30 non-APA attorney examiner job openings to support this initiative. Social Security Administration proposal raises important questions about whether cases heard by non-APA attorneys constitutes a violation of the Administrative Procedures Act. Further, Social Security regulation makes repeated reference to a claimant's right to an independent decision from an ALJ. SSA's newfound policy also raises procedural issues, given the magnitude and potential economic effect of Social Security Administration's proposed reinterpretation of its own rule here. It appears that the rule should also have been submitted by SSA to the Office of Information and Regulatory Affairs. Economics aside, the proposal creates an inequity where some claimants will receive the independent decision guaranteed to them by the APA and others may not. Furthermore, for non-disability cases, the loss of due process is compounded by the fact that a majority of these individuals are unlikely to have access to attorney representation due to the lack of a financial incentive for that attorney representative. But once a sizable number of claimants have been denied a hearing before an ALJ, there is the potential that Social Security Administration's proposal to move cases away from ALJs to non-APA attorneys could result in a large class action lawsuit. While we all share the goal of eliminating the hearing backlog, and I do agree, we all share that goal, it's our concern not just about meeting those results, we must also focus on how we get there. Accordingly, there are three main points I'd like to address today. First, I'd like to focus on how the attorney examiners drawn from the SSA's own ranks can be said to appear impartial, especially to the extent that they may review cases de novo. Second, I'd like to know more about Social Security Administration's policy pivot, which in the past allowed for certain transfers on a case-by-case basis to permit now large-scale transfers of entire classes of cases. Third, I believe we need to carefully consider alternative proposals to the Social Security Administration's untested and legally ambiguous policy, such as using retired ALJs from local offices to hear these cases or from video cases. Social Security Administration believes there aren't enough qualified ALJs to meet the current demand. Shouldn't they and OPM instead focus on new recruitment efforts to increase the supply of worthy applicants? There are a lot of issues as we deal with Social Security right now. There are some good success stories. I met yesterday with the Inspector General talking about the fraud that has been now exposed in the West Virginia case. It's a $600 million fraud case that's exposed. There are others on the near horizon. I'm proud of the work that SSA is doing in changing some of the processes with how they're handling ALJs and some of the oversight and some of the intentional things they're doing to be able to work on the backlog. We should have to make sure that we do this right. There are millions of dollars in each of these fraud areas, and there's a lot that's pending in case we have an exposed area for a class action lawsuit. It's got to be done right. We're happy to have with us here today Deputy Commissioner Teresa Gruber from Social Security Administration, Associate Director for HR Solutions Joseph Kennedy from the Office of Personnel Management, and Marilyn Zom, an ALJ from the Social Security Administration, to help us navigate these important issues. We're grateful for your testimony. I look forward to the issues we'll discuss this hearing. With that, I'd like to recognize the Ranking Member Hudkamp for her opening remarks.